Coalition. You've probably seen Stephen Housley here the last couple of weeks if you've been here. I've been out doing other things, but we have three main pieces of legislation that we're pushing this session. The first one of them is called the Texas Parental Rights Restoration Act. In a nutshell, the issue that we're dealing with the bill is that in the family code right now, it is legal for a judge to remove a child from a single-parent home and place that child with the mother or father-in-law of that single parent for an undefined period of time, and they do not have to provide evidence that the single parent is unfit or that the removal is necessarily in the child's best interest. We have been involved in cases where the child was removed from the home for 3 or 4 years at a time without there even being an accusation against the single parent that they were unfit to raise their own child. And the way that it typically works is that in most cases, the grandparents are going to have more money than the single parent is. And so there's some sort of legitimate disagreement that comes up between the parent and the grandparents over some parenting decision that the parent decides to make. Where we originally got involved is in the homeschooling issue, is that there was a case where mother and father-in-law sued the father because they wanted access to and they wanted possession of the granddaughter because they didn't think that she should be homeschooled. And they were able to remove the daughter for 4 years from the father's home. He didn't see her at all in that time period. And by the time we got involved in the case, he was actually representing himself in court and the grandparents were trying to put him in jail. And there wasn't even an accusation against him that he was an unfit parent at this point. And so the problem, from our perspective, is that the intent of the law is to allow for access between loving grandparents and children who want access to their loving grandparents. That is the intent of the law. The practical effect of the law, in many cases, is to put single parents in a situation where their parental rights are dependent on how much money they have. And so our position is that you're right as a single parent, or as any parent for that matter, to direct the care, control, and upbringing of your child is fundamental. And it is not dependent on how much money you have to defend it in court. One of the problems that we run into, and the way that it actually happens in court, is that a judge can remove the child based on temporary orders. And under the family code, a temporary order has no expiration date on it, which means that as long as the judge wants it to keep going, the temporary order will keep going. And the other problem, though, is that a temporary order in the family code is not appealable. It is not subject to normal appeal. The only way that you can appeal a temporary order in the family code is through what's called a mandamus, which has such a high evidentiary burden on it that it leaves a single parent with basically no judicial remedy if the judge gives an illegitimate temporary order. And so the way that we solve that problem in the bill, among other things, is we put a time limit on it. We say, look, if the grandparent is going to sue the parent for access to or possession of the child, there ought to be a reason before they come to court. And they should at least make the specific claim when they come to court. And then they have to substantiate that claim within 45 days of the time they file the suit. And so the purpose of that is to prevent these situations where the grandparents end up dragging the case on for 3 or 4 years and they win the case just because they have more money. I spoke with a single parent last session, actually, who came to one of our Capital Days events on this bill, who got up and left in the middle of the event, and I went out to talk to her, and she said, I can't be here, I didn't realize this was the bill you were talking on. And so I asked her what the problem was. And she said, well, I'm involved in one of these cases right now, and if the grandparents knew that I was here lobbying in favor of this bill, they would come after my children. And so we run into this situation where there are some single parents, in fact I got an email from one a couple of days ago, who feel the need to speak up about the issue but feel incapable of doing so because they are so afraid of the potential of their children being removed. The mother in question actually ended up having to give up custody of one of her children because she could not afford to defend herself in court. And it came to a situation where she asked the grandparents, all right, I'm going to lose everything, how can we solve this problem? And the grandparents said, if you give us custody of your daughter, we'll let you keep the son. And that's what ended up happening. And so we have a bill that we filed, Senator Donna Campbell is carrying it in the Senate, and Representative Cindy Burkett is carrying it in the House, that is intended to close that loophole. There's actually a bill that's been filed in the House and the Senate as well by the Family Law Foundation, which does basically exactly the opposite of what our bill does. Currently, the statute applies only to single-parent families. The way that the Family Law Foundation rewords the statute, it would apply to any family in the state of Texas. So when we sat down to talk to the Family Law Foundation about it, what they told us was, well, you know, we traditionally have to reject about 9 out of 10 cases that grandparents bring to us on this issue because they're not eligible to file suit under the law. And so our point was, well, you are now expanding that in your bill to include basically the other 90% of grandparents who you traditionally have to reject, right? And so the number of cases that you would see under the law would exponentially increase because now virtually every parent in the state is eligible to be sued. So we actually killed that bill last session. They refiled it. Interestingly enough, they had to get 2 new authors on it. And so I think the authors that carried it last session realized how bad an issue it was to carry. The 2 other bills that we're working on, one of them is called the Tim Tebow bill. The purpose of the Tim Tebow bill, which has been passed in 30 other states at this point, is to allow homeschool students to compete in extracurricular activities in the school district that they live in which their tax dollars are paying for. Currently, a lot of homeschool families, about 30% of homeschool families live in rural areas, and a lot of them have absolutely no opportunity to compete in extracurricular activities because either the homeschool leagues that they have there are too expensive, or there are no homeschool leagues for them to compete in, even though the public school they pay for might be across the street from them. And so our position is that if you're paying for it, you should at least have the ability to use it. And so we filed the bill in the Senate and the House. We had it actually carried last session as well. We got it all the way through the Senate last session. Expect to be able to do at least that without trouble this time. And Representative Harold Dutton actually is carrying that for us in the House, which surprises a lot of people. Harold Dutton is a senior Democratic member from the Houston area. And one of the reasons I think is interesting that he supports it is because if you look through the exclusionary history of UIL, UIL had its 100th anniversary this year. And actually it was 102nd anniversary technically. But it was the 100th anniversary of their exclusionary history because what happened was they were founded in 1913, and then in 1915 they amended their charter to exclude all homeschool students and all minority students. And so then in the 1960s, they amended their charter again to allow all minority students back in, but homeschoolers have never been allowed back in. So they've been excluded from the system for the last 100 years, even though in the early 1900s, the majority of students in Texas were actually homeschool students. So a lot of people don't know that, but it kind of puts some perspective on the issue. The third issue that we're working on is amending a section of the education code called the General Standards Law. The General Standards Law was passed, I believe, back in 2007, maybe 2003. I'm mixing up 2 different laws. But the purpose of it was that homeschool students are, in some cases, discriminated against by state colleges when they try and apply for admission to the college. And one of the ways that the colleges do that, actually 2 specific ways. Currently, the top 10% rule in Texas actually mandates that homeschoolers not be even considered for admission until the top 10% of all traditional private school students and public school students have already been admitted. So a homeschool student is only considered for admission after the top 10% of other students are already allowed into the college. Now, a lot of colleges have enough bandwidth that that's not necessarily an issue, but at colleges like UT Austin, for example, so much of their attendance is filled up by automatic admission that homeschool students don't necessarily, even if they get in, their major might be full already. So the ability of a homeschool student to get into UT Austin for that reason in particular is extremely difficult. There's actually a bill that I believe Morgan Myers filed that will change that and require, so to say that UT Austin is not required to accept more than 50% of their admission from the top 10% rule. And for that reason, we would support that. Yes.
Jeremy, you're not giving us any bill numbers. Go all the way back to the beginning.
All right, I'll restart and do the whole thing over.
No, I know HB 524 is parental restoration, right? What's the Senate bill?
Senate bill number is 414.
414.
Yeah, on the Parental Rights Restoration Act.
Okay.
On the Tim Tebow bill, the House bill number is, what's the House bill?
347.
347.
Okay.
There's the House bill number. And in the Senate, the House bill number is Senate bill number is 391 for the Tim Tebow bill. The college admissions issue that we are filing, that Senator Charles Perry is actually carrying for us, is 1543, I believe. Right?
1453.
1453.
Or no, third. Yeah, I think it's.
Try both of those languages, but I'm pretty sure it's going to be So
That's the dyslexia bill.
So the bill that Senator Charles Perry is carrying, it doesn't deal with the top 10% rule. It deals with the second admission problem that we've had, where the general standards law was originally filed to prevent state colleges from discriminating against homeschool students by stating that you have to admit a homeschool student based on the same general standards as you admit any other student. The problem is that state colleges started using class rank as a way to get around that problem. And they would say, well, homeschoolers have no class rank, so we're going to assign you a default class rank, and some of them assign it below the 50% mark, below average. And because you have a class rank below average, you are now required to score higher than most people on all of the entrance tests that you have to take to get into that college. And so we went to the Higher Education Coordinating Board and we said, look, this obviously bypasses the intent of the law because you're holding a policy that affects homeschoolers completely differently than every other student, right? You have to score higher just because you're a homeschooler. And the Higher Education Coordinating Board said, oh, yeah, that's true. We'll see what we can do. And so then they wrote back to us and they said, yeah, we'd let the colleges know that it's a problem, thanks, basically. So that didn't do anything. So in my opinion, actually, the policy as a whole actually violates the obvious intent of the law. But instead of taking that to court, we decided to just fix it from a legislative perspective. So the way that the bill works is it said that if a state college is going to admit students based on class rank, they're not allowed to assign a default class rank to a homeschool student that is below average. And then it also requires that any admission criteria that they use specific to testing be applied equally to homeschool students as applied to non-homeschool students. And I am pretty sure that the number is 15. I will actually give a quick plug for Senator Donna Campbell's bill, the Taxpayer Savings Grant, which I believe is up on Thursday. All right? Yes. So the name is Texas Homeschool Coalition, but we actually deal with a variety of issues from parental rights to school choice issues. And so we've been supportive of that bill from a school choice perspective. So if there are any questions, I can take those real fast. I think we might be a little short on time.
Just a quick comment on 276. There's a Senate Bill 4. They're taking grants and scholarships and combined them and made some significant changes to both of those. You might want to take a look at it.
Senate Bill 4?
Yes.
I can't remember if I've seen that one or not. I'll look at
It was just filed.
I want to make a quick comment about the Parental Restoration Act.
Sure.
If a woman was sexually abused for years by her parents, and it's a team sport, and then she dies, if there's no police record of that, her parents can then ask for possession of the kids. Okay? And I met with my rep, and his response was, well, you know, I had some grandparents say otherwise. Grandparents vote. So if you really care about the family, this is a great thing to go in as a grandparent and say, I vote. God gave children to parents, not to grandparents. And if you want to have a relationship with grandkids, they need to keep a relationship with the parents. And so it's really something you can have a powerful impact as a senior. And I encourage you to do that. So.
And we have had a case where that happened, actually, where the daughter ended up being placed for 2 years with the grandfather who was a child molester and who nobody knew about until she got out of the home afterwards. So that does happen.
And should in that case the father be abusing the kids? We have CPS, we have all kinds of laws in the books to go and get him and get the kids and protect them. So it's kind of a red herring to say, oh well, we heard that something else was happening, because that's already on the books. So there you go. I encourage that. And I would also say ALAC does a lot more wonderful things other than above and beyond protecting women's rights about American law for American court. It doesn't allow judges to opt out and kick things back to Pakistan or whatever. It's very nice.
And I think if there are no other questions, I think that's it.
All right, well, Michael had to run away.